everyone, my name is Heather Koering, and I am an attorney with Eastlund, Solstad, Cade, and Hutchinson. We're located in Savage, Minnesota. I first became involved with MOCA in 2002. At that time, MOCA was working out of founder Molly Cade's house, and Molly decided that they needed more space. They were taking over the garage, the basement, all over the house. And as her husband, Joe Cade, who's one of the other attorneys in our office, Joe tells the story a little different. He says, Molly was taking over the house, I had to kick her out. So whichever story it is, there's some sort of combination between that. But anyway, they outgrew Molly's house, and then they came to have take over one of the offices in our office. So that's how I first became familiar with MOCA. All right, let's move on now to the second essential legal document. So the second essential legal document is a financial power of attorney document. A financial power of attorney document is a document which you set up, which allows you to appoint an agent to act on your behalf with respect to financial decisions. The healthcare directive covers healthcare decisions. The financial power of attorney document covers financial decisions. So the benefits for having a financial power of attorney document in place are that they're, again, inexpensive, they're easy to do. It's very nice to be able to have someone in the event that you can't act who can pay bills on your behalf, who can transfer assets around if needs be, who can just essentially step in and take care of those financial decisions on your behalf. And it's also, like the healthcare directive, the financial power of attorney document is revocable at any time. So you might do it and then decide later on you want to change something or you want to nominate someone else. Well, it's easy to do. You revoke it and you nominate someone else to act on your behalf. So the downside with a financial power of attorney document is that there's no real obligation for your financial agent to act. They're not under court supervision. They're not directed by the court. They're not under any legal legal duty to step in and do something on your behalf. You're simply trusting them that they're going to take on this responsibility and take on the authority and the direction and step in if you're unable to do so. So let's look now at the financial power of attorney document itself. So this is the second document that's in the packet. So on page 1 of this document, you would be the principal or the person making this document. And down where it says attorneys in fact, that's a fancy word for your financial agent. So that's where you put in who you want to act on your behalf. And again, like on the healthcare directive, we have an attorney in fact and we have a successor attorney in fact. Because we always like to have backups in case something happens to your first choice, that you have a backup in place and someone else can step in. Similar to the healthcare directive, you can appoint co-agents to act together. So same situation, you might have 2 people you want to act or 2 people that you trust, 2 children, whatever the case may be. You can certainly nominate them to act together. But similarly, so to my caution on the healthcare directive, I would make sure that these individuals, if you want to have co-agents, that they get along. Because there's nothing worse than having co-agents or in any sort of thing that do not get along, do not agree, makes the process a lot more difficult. So let's switch now to page 2 of this document. So on page 2, where you see this first section here towards the bottom, and there's a bunch of options listed under A through M, with N being all-inclusive. Those are all of the powers and authorities that you can give to your financial agent. So you can be restrictive and say, I just want my financial agent to be able to do banking transactions, or I just want them to be able to deal with real estate. You can make it as limited as you want, or you can check box N, which is all of the above. So they can act in whatever situation and on your behalf with respect to any type of financial decision or asset. We generally recommend that you do box N because you don't know exactly what the situation may be, what may arise, what may need to be done. So you want your agent to have the broadest range of power to act on your behalf so they can do whatever needs to be done. So one less thing to worry about. All right, now let's switch to the next page. So on this back page now, the second option at the top, this relates to the durability of the financial power of attorney document. And what that means is if you want it to be durable, which is option number 1, it means that this document will continue to be effective in the event you're incapacitated or incompetent. And frankly, I think that's when you want to have it in place. If you can't make decisions on your behalf, that's when you want someone to step in and be able to continue to pay bills or whatever the case may be on your behalf. The next option there relates to property transfers to your financial agent. So do you want them to have the broadest range of power and be able to transfer property to themselves? Or do you want to restrict that and say they can transfer property or pay bills, but they can't do it to themselves to eliminate the possibility of any self-dealing that may occur? However, when you're appointing someone to act as your financial agent, there's most likely a lot of trust that's there too. So, I would guess that that's not really a concern, that you're worried about your financial agent absconding with your checking account and fleeing the country or anything like that. So, in all the years that we've done powers of attorney, that's happened in one situation, and unfortunately, daughter went and cleaned out mom's bank account, and off she went. But in all the hundreds, if not thousands, that we've done, it's such a rare occurrence. Next and finally on this document is the option for an accounting. So you can require your attorney-in-fact or your financial agent to give you an accounting, which is simply a list of what have you done with under my power of attorney. Give me a list of what bills you paid or what assets you've transferred or whatever the case may be. And lots of times it might be fun to say, yeah, I want my agent to give me an accounting on a monthly basis or on a quarterly basis. But chances are that you're going to do this and set this up in place, and you may or may not need to use it, but it might be fun for the first couple of months to give an accounting. It probably would get old after that, or there might not even be anything to account for. So, we generally say that second option, or the first option there is better, that says, if you request your attorney-in-fact to give you an accounting, so if you say, hey, financial agent, give me an accounting, then they have to give you one. So, whereas you can eliminate that regular basis, the monthly accounting basis. And then, like the healthcare directive, in order for the power of attorney to be valid, it needs to be signed and notarized. So, it's a pretty straightforward document. It's very easy to do, very easy to set up in place. If you don't have one of these in place, then the alternative is that your family or friends or whoever the person is, they have to go to court. They have to get a conservator appointed to act on your behalf to make all of these same decisions that a financial agent would make. And that is costly, time-consuming, and very involved. So it's easy to set up one of these in the alternative.